So you can't enter into moment you say, okay, I'll recognize these three people, I will entertain these two people, and then now you have lost majority, now you have a floor test. So impermissible. That's the old non-10th schedule regime, the Ayagram, Gayaram regime.
So, Sybil, the only problem is, I'm just looking at it from this point of view. The basic principle of parliamentary democracy is that a government has to be accountable to and must have the faith of the House. Now, suppose a group of, say, the government has X number of legislators, and take a hypothetical case where X divided by 2, say that we have no faith in this government, though we were elected on their ticket.
Correct.
They say that, look, okay, we incur the disqualification, but we don't have faith in this government. Now, going by your logic, the governor can never call a trust vote because he will say, look, you have been elected as members of the House. You can't say that you have lost faith in which case, even though the government now really effectively has only X by 2 of its confidence in the House, the strength in the House, still the government must continue. The government has to continue. It's basically reduced to a complete minority, probably.
Your Lordship is absolutely right. May I answer that, Malaz? The session is on. Finance bill has to be passed. Vote against it. Government will fall. What's the problem? This is not an insurmountable legal issue, Malaz. Any vote against it. But what they want is, they want to topple the government, become the chief minister, then tell your Lordships, now the speaker will decide. This is not constitutionally permissible. Your Lordship is absolutely right. What time does the government lose majority, lose confidence of the House, Malaz? At the time when it is reduced to a minority. At what time does it reduce to a minority? When they vote against the government. It is reduced. That's the solution. Till the time they vote against and the government becomes a minority, it's accountable to the people. The governor cannot assume that they have lost majority, therefore there is no accountability. That's not permissible as far as the governor is concerned. That's respectfully the responsibility to the query that your Lordship raised. Prime Minister Narasimha Rao ran the minority government. It's not as if governments can't be run by minorities. Point is, they don't want to lose the membership of the House. It's a double whammy, Malaz. You lose the membership, you don't become a minister. You have to fight an election. You may win, you may not win. Here, you topple the government to become a minister, you become a chief minister. Use the governor's office for that. Your Lordship, Malaz, I don't have to say anything more. My political experience and your judicial experience, Malaz, we have reduced ourselves to that we are mocked. People don't believe us anymore. We are not against the floor test. We're against the considerations on the basis of which the floor test was ordered. This court cannot say that you cannot decide or I give 10 more days or 10, 15 days. That's not the power. That's not the function of the court. It is straight law that neither the governor nor for that matter this court has the power to impinge upon the authority of the speaker to take a decision on the above issues. Malaz, now 5 judges have said that. Therefore, Malaz, that order on the 27th put us in a situation, Malaz, where the elected government was toppled. Neither the governor nor for that matter the court can entrench upon the power of the speaker, which is why I pointed out paragraph 6 of the 10th schedule and 180. Because there can't be any hiatus. Speaker's function must continue. And there cannot be any Kitamek order. Even in Shivraj Chauhan, your Lordship said, because there was no interdiction there. So the court said, in Shivraj Chauhan, the speaker could easily disqualify. But in this case, what happened? The speaker could not move. So how does Shivraj Chauhan an authority for the proposition that a floor test is necessary in these circumstances? Malaz, when Bomai was decided, and Malaz, Bomai set aside orders under Article 356, Malaz. What did Bomai say? Bomai said, we have to restore the status quo ante. It doesn't matter what happened thereafter. Bomai said so. Shivraj Chauhan also said so. We're not asking your Lordship that what Bomai said was the acts that have happened in between can be validated by the court, right? Because there's legislation that is passed, there are other things that have happened. Those acts will be validated in your final decision making. But we cannot say that we can't have the status quo ante. Status quo ante, that's how Arunachal Malaz was decided, how it was decided. Only on that basis. Status quo ante was restored. It also happened in Uttarakhand, Malaz, when this court restored the chief minister, Malaz, by setting aside the order of the governor. So we are not saying, Malaz, that everything that happened thereafter is illegal. No, we are saying that's the molding of the relief as and when your Lordships decide one way or the other. An invalid proclamation would nevertheless have to be set aside. So this argument, Malad, that was according to an argument of frustration. Because you are now saying, look, subsequent events have happened. I am the chief minister. I am enjoying the fruits of power. Please don't do anything. Now there is confidence in me in the house. All irrelevant. Womai says so. The remedy of judicial review would be rendered meaningless. How much more eloquent can the court be on this matter? Well, what's the point, Malad, of now saying these consequential acts have happened, so you have no judicial remedy, even though the act may be illegal? Where does the governor get this power from? Who is he recognizing? Leader of what? The governor can only deal with the legislature party. He can't pick out Eknath Shinde and say, now you become the chief minister. It's like saying that the party is registered with the election commission. The leader is as communicated to the election commission, but I, as governor, will pick up another leader contrary to what is communicated to me. The leader continues to be Malad. On the 30th of June, Uddhav Thackeray was the leader of the Shiv Sena political party, representing the rival faction which ought to be recognized as a political party. Now, Malad, this is the cat is out of the bag. Now he is saying outside the constitution, outside the principles of constitutional law, a faction in the legislative party should be recognized as a political party. Without going to the election commission, without registering yourself. What political party? I just don't understand on what basis my learned friend made this submission. The whole purpose of the 10th schedule is to talk of the legislative party and the political party as separate entities and to prevent acts which would amount to disqualification. That's the whole purpose. Whereas the Constitution doesn't recognize that. Even the Representation of People Act doesn't recognize the legislature party. It is only in the 10th schedule because you wanted to prevent acts of disqualification. The respondents have repeatedly asserted that there is no distinction between a legislative party and a political party. And again, quote from the transcript, we have consistently said so, that a legislature party is integral and originally connected and co-joined to a political party. What's the basis of this submission? And I still say, I am the original political party. So first he says, I am a faction. Now he says, I am the original political party. Because that faction should be recognized by the governor as the original political party. Now they are presuming that this is only a rival faction. He just said that it's a faction within the legislature party and not a rival faction within the political party. Whereas your lordships have time and again said, you can't segregate the two. A legislature party is also an extension of the political party, has the authority of the political party. Where does he get that from? Decision of the legislative party has the authority of the political party, unless he says, my faction is the political party. Now, your lordships will remember, all this happened much before the matter went to the election commission, because there they moved on 19th July. So, all this is so per se unconstitutional. Well, this whole argument was raised in Kyoto in the context of Article 105 of the Constitution. Rejected. Why? Because you are a representative of the political party and bound by the discipline of that party. You have no independent right. Unlike Parliament in England, unlike the Senate and the House, and unlike European Parliament. This court is distrustful of that, is what Kyoto says. Now, disloyalty is for a price which has secured him the chief ministership, if I can put it differently. And this particular litigation is a shining example of that political declaration. We should, we think, defer to the legislature's wisdom and perception, saying we know the reality, and that's why the 10th schedule, that's why they must not crossing the floor must not be allowed. But whatever may be the consequence, that disqualification has already happened. Even if the election commission's order is right, which is ex facie wrong, but we'll deal with it separately. This disqualification has happened. That cannot efface the disqualification.
Only one thing which they have said about whip is that they have referred to the disqualification rules.
Yes. Oh yes, I have to deal with that.
Perhaps you may want to...
I'm sorry, I should.
Related to 3-1...
I'm going to show that immediately, but that's my mistake. I should have, in my desire to finish quickly, kindly go to those disqualification rules. Leader in relation to a legislature party means a member of the party chosen by it as its leader. Member of the party chosen by it as its leader. Complete misreading of this definition, and includes any other member of the party authorized by the party to act in the absence of the leader. Authorized by the party. Consistent, with all my contentions. This is not in the domain of the legislature party. The party chooses the leader, the party chooses the whip. So this argument that I had thrown you out, Sunil Prabhu I had thrown you out, therefore I need not have recognized Sunil Prabhu at all on the 3rd. Because I had appointed Gogavle. Amalas, yesterday, an argument was made. How could they whip act outside the house? Amalas, what were they doing in Assam? Appointing a whip outside the house? They made a serious argument yesterday. This is a whip. How could they do it outside the house? So you're sitting in Assam in the lap of the BJP and you are displacing a whip which is recognized by the political party and conveyed to the speaker, and these office bearers are there on the record of the register of the assembly. And you say Gogavle is the whip. I mean, it's per se voluntarily giving up membership. You say I continue to be the leader. On what ground? You've been removed on the 21st of June itself. So how are you the leader? Well, kindly look at it this way for a moment. Well, supposing I say I am the party, what should I do? I should go to the party, call a meeting. There are rules of the party. Go and establish your majority in the party and then become the chief minister. There may be no dispute in the legislature party. Take a case, Malas, where there is no dispute in the legislature party. What would a person do if he says that, look, I am the party? He will go to the party. He can't do it any other way. Now, if you are able to galvanize the support of X number of members, there may be minority, there may be majority. And then on the basis of those numbers, you destabilize an elected government and then go to the election commission, and on the basis of the fact of those very people who are subject to disqualification, get the symbol and then say, I have the party. Which of the two Mullat's procedures would be constitutional? Mullat's members of the legislature can never be given primacy over the party. Can never be given. Because they are individual members, Mullat's. Group means you may actually act together. That's not relevant. So Mullat's, this is one part that they relied upon. Then para 3. Then Mullat's, my Lord the Chief Justice asked a question, or one of your lordships asked him a question. Is the whip mentioned in the form? And the answer is yes. The fact is it is not. Their argument was, no, the legislature party appoints the whip. And they gave that document to your lordships, which is contrary itself to the record. Because that's a Rajya Sabha member appointing with it. So that's, I've done with this part of it. Now, a bit about Mullat's Nabam Rebia, if your lordships will permit me. Mullat, as far as Nabam Rebia is concerned, Nabam Rebia does not take into account the ambit of Article 179 of the Constitution and the concept of removal in 179.
Does
If
not
it
take
removed
into
from
account
it.
the concept of removal in Article 170.
Yes, removal in 179C, Mullat, not dealt with at all. It's like not a no confidence for which no reasons have to be given. Intention to move. Your lordships will remember the submissions that I had made. The question of moving doesn't arise. Intention to move. So that concept, Mullat, not dealt with in Nabam Rebia at all. What does Nabam Rebia say on the issue of 10 members, Mullat? My learned colleague, Mr. Jethmalani Mullat, said that seemed to be an erroneous interpretation. Then members means then who are members of the House at that point in time. That will exclude people who are disqualified. But Nabam Rebia says, no, you can't change the status of the House, even if there are disqualification. In a sense, saying that you can't even deal. The Speaker can't deal with disqualification petitions. That's Mullat also an area where Nabam Rebia Mullat did not deal with it. That's the second. And the third is, Mullat, just look at this notice. I am talking about the concept of removal. I'm not talking about, we are not here talking about whether the article is referred to or not. No, not the ground. This is the whole point. That issue was never raised. It was means, many things you have said happened but didn't happen. So let's not go into it. But there is no discussion as to, but kindly, there's a difference between notice for removal and a mere notice without any grounds for removal. They misinterpret, according to me, Mullat, this could not have been the law in Nabam Rebia. Could never have been. They write a letter saying, now I want to remove you. That's it. It's not a no confidence motion. It involves, Mullat, consequences, civil consequences. I am holding an office under Parliament. I am removed from that office. I am not told why I am being removed. Yes, that's why the Constitution says at the time when the Legislative Assembly is in session, remember I read that? At that time, if it is moved and it is under consideration, only on that occasion I cannot sit. I have to go down to the House and I can participate in the proceedings and put my point of view. The procedure itself tells you that inherently in this process are reasons for removal.
What you're saying is simply saying no longer enjoy the support of the majority of the House means nothing. This is what you're saying.
So Nabam Rebia has to go. It's in that context that I mentioned 179C, Mullat. So Mullat, this, first of all, this is written when? When this group, whether it's 34 or 39, are sitting in Assam. They know on the 21st of June that Eknath Shinde has been removed. Right, Malaz? So it is in that context that this document is written. So obviously it's a self-serving document. It is not a document that sees the light of the day prior to 21st of June. It doesn't talk of any event prior to 21st of June. It makes some general statements that our cadres are unhappy. It refers to no such event. It refers to no such event when he has aired his views publicly prior to 21st of June. It refers to no such communication to the Chief Minister or to the party office prior to 21st of June. It's a self-serving document to justify the switch to the BJP on account of corruption in the government. But till the other day, till 21st June, he was the minister and he was the group leader. No, and corruption is not relevant, Mullahs, as your lordships have already read in Boma itself says, corruption not relevant even for 356. Forget about this. So, Mullahs, what's the credibility of self-serving statements of a document when you're sitting in the lap of the BJP in Assam, knowing full well that you have been removed as a group leader and that Ajay Chaudhary has been appointed?